Right, I think we should start. It is 12 o'clock, so good morning and welcome to WorkLaw's webinar on managing poor performance, incapacity, poor work performance. My name is Bruce Robertson. Those of you who don't know me, in the other screen, Alan Rycroft from Cape Town. I must say it's a miserable day here in Durban. It's pouring with rain, and I see Cape Town's bright sunshine. So Alan, I hope
Perfect
you're
day here.
enjoying the day in Cape Town. We'd like to welcome our subscribers, and those of you who are not yet WorkLaw subscribers, we'd like to welcome you as well and hope you enjoy the webinar. There are two broad themes to this webinar. The first is to deal with practical nuts and bolts issues of managing incapacity, poor work performance. And we'll give you a chance to ask questions. Please use the Q&A function at the bottom of your screen, and we'll then deal with those questions at the end of the webinar. We aim to speak for, it depends how long-winded Alan is, but we aim to speak for about 45 minutes to an hour, and then we'll deal with your questions as best we can afterwards. You don't have to take notes. We do have a handout of the material that we will cover and all the cases that we'll be mentioning, and that will be available on the WorkLaw site after the webinar, and there will be a video of the webinar that will also be available up on the site. So as I said, I began to say that there are two practical themes. The first is dealing with nuts and bolts issues that you might experience in managing incapacity, poor work performance. And then secondly, if you ever had to defend a dismissal based on incapacity, poor work performance, looking at the kind of evidence that you would need in order to prove procedural and substantive fairness. So those are the two broad themes that we're going to focus on. And can I start by highlighting the importance of identifying, if you ever have a dismissal that you're going to have to defend at the CCMA or in the Labour Court, to even from the time that you are involved in the actual dismissal, to identify the type of dismissal that you're dealing with. Because the Code of Good Practice lays down procedural and substantive fairness requirements, and they're different if you're dealing with misconduct or incapacity. So you need to know the yardstick against which your fairness is going to be measured if it's ever put to the test in an arbitration or in the Labour Court, to make sure that you get it right first time. The Code of Good Practice, it deals with incapacity under two broad headings. The first is ill health, and the second, which is the focus of this webinar, is on poor work performance. And the first question to ask you is, are there any other circumstances out there that could fall broadly under the heading of incapacity, even though the code only deals with these two particular species? And I'm going to ask you a question. We do have certain questions to ask you during the webinar, and I'm going to ask you some questions and see what you think of them. Just give me a second to find them. First question I'm going to ask. The Dismissal Code of Good Practice talks about ill health and poor work performance incapacity. Are there other circumstances that could constitute incapacity? Make your choice. Can I say that we don't see your individual answers? All we see is the percentage of you that have voted yes or no. Try and cast your vote in the next 10 seconds or so. Okay, your last chance. All of you in, I hope. Counting down, 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. I'm going to end the poll. Share the results with you. Hopefully you can see the results up there on the screen. Well, 68% of you say yes. And let's look at that, and let's look at various labor court judgments and so on that have dealt with other circumstances that could constitute incapacity. Alan, do you want to talk us through some of these?
Yes, I can understand why there was quite a division in that poll, because over time, the courts have had to look at a number of quite different situations, circumstances, and decide, what does this look like? Does it look like misconduct? Does it look like incapacity? And they started to gather their thoughts around this kind of test. Does this particular problem impact on work performance? That was almost the test. And if it did, they said, we're going to call it incapacity. Now, the first one was something which we get lots of helpline queries on, is the issue of imprisonment, or maybe just arrest, or the employee, word comes to the employer that so-and-so's was arrested over the weekend, and they just don't reappear at work for a long time. And we get queries about what should we do? The courts have settled the Simanko court case. Now, the second case there, the SCA, is actually the appeal judgment, just so you've got both of them in your notes. Here you have a furnace operator who's arrested on suspected robbery, and after about 150 days, the employer really doesn't know what to do. This goes, as you can see, goes to the LAC and then on to the SCA, and it's confirmed that incapacity can take the form of the person just being unable to perform, an impossibility of performance, and the employer can legitimately and fairly dismiss in that kind of case. There are some procedural issues which must be followed, they say, like contacting the person in prison and getting representations, but that it's not a very heavy procedure, but nevertheless, it's seen as incapacity. The second situation is a loss of a security clearance, or could be loss of a license, particularly for drivers. But why we put down security clearance, because the leading case deals with that. It's an arms court case where, in terms of statute, as well as the employment contract, employment was conditional on the employee getting a clearance certificate and maintaining it. In this case, it was rather bizarre. An employee of 30 years, who for 30 consecutive years got his security clearance, was suddenly denied it. And he was then, the employment contract was terminated. And it ended up, again, at the Labour Appeal Court. And they had to decide whether the loss of the security clearance meant he loses his job, or whether was there an obligation to keep him employed in another capacity. And despite his long service, it was held that that situation, the loss of a license, loss of a clearance, was enough to justify termination. The third circumstances which arose the last couple of years is a refusal to be vaccinated. There is a case which might be decided differently today, but here you have a situation where the employee indicated that she had no intention of being vaccinated, and that was found. It was a CCMA award held it to amount to permanent incapacity. As I say, now that we know a little bit more about COVID, I wonder whether it would be still called permanent incapacity today. But anyway, that's what was held, and it could apply if there was another pandemic. The last circumstance, and a far more complex one, is incompatibility. Because why it's complex is that usually manifests itself as misconduct. There's one employee that is toxic, causing problems with other employees. And it looks like misconduct, doesn't it? In the Zeda car leasing case, the Labour Appeal Court has confirmed very definitely that incompatibility, because it impacts on performance, work performance, it is a category of incapacity. The facts here were quite interesting because it shows you how the wrong way to deal with incompatibility. The employer, faced with two managers who were just incompatible with each other, decided to have a structural change and told them to apply. They were going to merge the two positions and they could apply, both could apply. And needless to say, the employee who didn't get the job took this matter to court. And it was found to be procedurally irregular because neither of the two employees were consulted on this decision to rationalize their two positions into one. But it was the wrong way to deal with incompatibility, but the court did confirm that incompatibility was a form of incapacity.
Ellen, so given the fact that there are other types of incapacity which are not specifically covered in the Code of Good Practice, how would you recommend that employers deal with these? Which guidelines do you think they should adopt and adapt?
Well, I would think that because now the courts have said these things, imprisonment and so on, are a form of incapacity, I think employers have got no option but to modify the incapacity procedural requirements in the Code of Good Practice. And that's really to have an inquiry, to allow representations, to allow a trade union rep if necessary, to consider alternatives to dismissal.
So get practical. So if someone's in jail, how long are they going to be in jail for? How long is it a temporary issue? Is it a permanent issue? Can they employ an alternative person whilst the person's in jail? Is it?
Yeah. That's the kind of considerations that this inquiry would have to take. But I do think there's got to be an opportunity to give the employee a chance to make representations. But for the person in prison, it might be in writing, or it might be through an interview, someone visiting the prison. But there must be some attempt to contact the employee.
Yeah, I see someone's raised their hand. We aren't going to take questions during the presentation. So if you do have questions, please use the Q&A function at the bottom of your screens, and we'll deal with them as best we can at the end of the webinar. Moving on then, let's look at whether poor work performance can actually constitute misconduct or incapacity. And what do you think about that? Let me ask you a second question. Hope that's come up on your screens. Can poor work performance constitute misconduct or incapacity? What do you think? Couple more seconds just to give you a chance to cast your vote. What you're seeing there is 94% of you say yes, and let's examine that. Let's examine a case that deals with that. So what I'd like to do is share with you on the screen. It's the Goldfields case. Again, it's a Labour Appeal Court judgment. In this case, the employee, just to give you briefly the facts of this case, the employee was a sampler. He was responsible for collecting important data underground, which had important consequences for how the mine operated. He took the wrong measurements. He was charged with serious neglect of duty, and he was dismissed. This went to arbitration at the CCMA. The arbitrator said, no, this was a case of incapacity, poor work performance, not misconduct, not serious neglect of duty. And he found the sanction of dismissal was too harsh, as he felt that the employee's conduct could be corrected and improved. and he reinstated the employee. This went all the way up to the Labour Appeal Court, and the Labour Appeal Court said that the arbitrator had incorrectly processed this matter and judged it as a incapacity case, whereas it was in fact a misconduct case. This employee knew what was expected of him, and yet he failed to perform and carry out his functions. And the Labour Appeal Court said he'd committed a serious act of misconduct, which justified his being dismissed. And in the course of the judgment, the Labour Appeal Court spelled out a very clear outline of when poor performance would constitute incapacity or misconduct. And they said incapacity involves an employee failing to meet a performance standard due to a lack of skills, knowledge, or competence. Whereas misconduct, the employee has the capacity to do his job, but intentionally or negligently fails to meet the performance standard. So there you can see a clear outline of those circumstances when you would deal with poor performance as misconduct, or whether you would deal with it as incapacity. Let's then look at what the Code of Practice says about how the key requirements for a fair dismissal dealing with incapacity. And there are a series of questions which the Code of Good Practice asks. And it says, did the employee fail to meet a performance standard? Was the standard reasonable? Was the employee aware of it or ought to have been aware of it? Was the employee given a fair opportunity to meet it? And that's often is the key issue in a dispute of this nature. And lastly, was dismissal the appropriate sanction or not meeting it? And those are the key questions that the Code of Good Practice asks. And we're going to take you through each of those and look at the problems which might occur under each of those headings and what evidence that you need to prove if any of those were in dispute between the parties. Alan, do you want to kick off and deal with the first one as to whether or not an employer has failed to meet the performance standard?
Yeah, there's some jobs where knowing what the performance standard is much easier than others. For example, number of sales made. But in others, it's just quite difficult to quantify what the performance standard is. And I think the key learning from most of the cases is you can't just depend on the subjective opinion of the manager. There's got to be some measurable objective criteria to judge things. And this emerged quite in a couple of cases. There's this KPAB versus Schuster case. As you can see, it involved the Cape Performing Arts Council, and Schuster was a trumpeter employed on a temporary basis, a testing period, probation, I suppose, as a trumpeter in the orchestra. And there was a feeling that he had made no progress. And so they extended the probationary period. But he still didn't know by which criteria he was being judged and how was the performance standard to be measured. And that's just what was said by the Labour Appeal Court in this case, that there's got to be some kind of known, and well, certainly known to the employee as well, what performance standards and proper evaluation before there can be termination of the contracts. And the other case is Human and Santam. This case involved an in-house lawyer, and you can imagine an in-house lawyer. How do you measure the performance? Is it on whether he wins the cases at the CCMA or loses them? You don't quite know. And the CCMA arbitrator said here, the evaluation of the performance in this case was entirely based on subjective opinion of the supervisor, just anecdotes, no factual evidence. And so this case is a reminder, there must be a factual base before an employee can be accused of incapacity. It might be really important for the employer to sit down with the employee to say, look, let's have agreed criteria. Let's establish what represents your performance standard. So, Bruce, I think those are the cases that I would illustrate the need for a performance standard.
How would you be able to test whether the standards are reasonable?
I think you could look at other employees who do the same job. And if other employees are meeting that performance standard, or it could be previous employees, the employer might be new and has replaced someone. And if the contemporary or previous employees met those standards, I think that would be the evidence the employer would use and rely on to say the performance standard was a reasonable one.
Okay. Are there any cases dealing with that? Those aspects?
Yeah. There's the Sun Courier's case. Here you have a sales executive with 8 years experience. So he's got a long track record of meeting the standard. In one particular year, he failed to meet the minimum target set. And in that case, the confirmation by the Labour Court that an employer is entitled to set standards, and unless they are patently irrational or unrealistic, the court won't interfere.
But that's quite a useful case for employers to use to, if ever there was a challenge to the reasonableness of the performance standard.
Yeah, we'll come in a moment to a case where there was unrealistic targets, and I think I'll deal with it more there. The Old Mutual and Dreyer case is a complex one and very interesting. It involved insurance advisors and who had received warnings about their poor work performance. That hadn't been, they said that their sales targets were completely unreasonable. And so what did they do? They resigned and claimed constructive dismissal. In other words, that's a claim that the employer has made things absolutely intolerable, and therefore their resignation should count as a dismissal. Here, the Labour Appeal Court says you can't claim constructive dismissal, and if you haven't tried to resolve things using internal procedures. And the grievance procedures, as it were, is an opportunity to debate the reasonableness of the targets. This case also is an important authority for this proposition, that simply announcing to employees that there was going to be disciplinary hearings cannot be counted as duress justifying a constructive dismissal. So just because you've said, look, we're going to have some kind of disciplinary process, does not suddenly entitle employees to resign and say constructive dismissal.
Okay. So we dealt then with whether or not an employee has failed to meet the required performance standard and whether it's reasonable. And if you have any questions on those issues, please pose them in the Q&A function, and we'll come back to them at the end of the webinar. And the second point then on that list that we put up on that slide was whether the employee was aware of the required standard or ought to have been aware. And the kind of evidence that you would use there would be perhaps these were stated in the person's contract of employment. They might be in emails, they might be in minutes of meetings. You might have to call the manager to give evidence to say he or she spelt these out, and they might give verbal evidence on that. But you would have to prove, if it was in dispute, that the employee was made aware of the required standard. And the next issue is whether the employee was given a fair opportunity to meet the required standard. And what we often get asked on work law helplines is someone hasn't met the required standard and they placed on terms and they said, you know, you're not performing at the required level and we're giving you 3 months or a month or 2 weeks to meet the required standard. And if you haven't met it, well, then your job's at risk. And let's ask you whether under those circumstances that would be enough to meet the employer's obligation to give a fair opportunity to meet the required standard. So here's a question that hopefully has come up on your screens. If an employee is performing poorly, is it sufficient to warn the employee that she may be dismissed if her performance doesn't improve by a specified date? Is that all you need to, in fact, do to satisfy the requirement that the employee was given a fair opportunity to meet the required standard? Let's see what you think. Few more seconds. Well, I see that 87% of you say no, that is not enough. And let's look at that. It certainly isn't enough. Let me just call up something on the screen for you. What the code says is that in item 8.2, after probation, an employee should not be dismissed for unsatisfactory performance unless the employer has A, given the employee appropriate evaluation, instruction, training, guidance, or counseling, and B, after a reasonable period of time for improvement, the employee continues to perform unsatisfactorily. So it's not just a question of placing the employee on terms, on notice under B. You've got to comply with A. And what's obviously contemplated here is a performance management process where there's a counseling process, there's evaluation, there's feedback given, there are a series of meetings arranged that you give this employee sufficient help. And the key question really here is, has management sufficiently equipped the employee to perform at the required level? That is the sort of key question that you would ask yourself in judging whether you've done everything that's necessary under this heading. And there are obviously a number of issues that now arise out of that. And the first is, for example, do you have to retrain this employee completely from scratch? Alan, do you want to comment on that?
I think that the obligation to train and retrain is going to depend on the circumstances. There's one case, perhaps you can call it up, Bruce, the Satawu case, where the employee had previous training and qualifications. That's why he was hired. And this case said that where the employee presents as a qualified employee, then they do not need the same level of counseling and guidance as a novice who has to be trained from scratch. But the court went on to say that even though a person says, I've got the qualifications, I've got the experience, the employer must still provide clear and regular analysis and of any perceived incapacity and give guidance. I just reading recently, Bruce, that now that technology is getting so advanced that in the US, employees are obliged to wear special watches with little screens on. And if they aren't sure, they can actually look at little training videos there on the job of how to do things. So that's obviously a form of training on the job right there to meet all that kind of uncertainty about performance.
Yeah, I mean, in my view, broadly speaking, obviously it depends on the facts of each case. And I think, for example, an employee who is promoted into a more senior post, there may be even a greater obligation in those circumstances for the employer to provide the appropriate skills and so on to equip that person to now perform at a higher level when they were previously employed at a lower level. And it does depend on the facts of each case. But I don't think in broad terms that the employer is expected to retrain the employee completely. They come on board, they are employed on the basis of of having certain skills and so on. And if there's certain key areas that they're having problems with, then I think those need to be addressed as a part of this process. Alan, how much time ought to be allowed for this type of process? I mean, what are you talking about? A year, a week?
I think once again, it's going to vary according to the job. But my gut instinct is you really need a period of, particularly if it's in the initial stages, 3 to 6 months to get the person settled in their job. But you know, I think we learn from the hard cases, and the one that's I think is really fascinating is this Damlin case. The employee in this case was appointed as the general manager of the Boksburg campus of Damlin. And that's when he was appointed, there were 352 students, and this is important, and 168 of those were first years. Now, he was given a performance standard that he had to get 420 first-year registrations the following year. And so that's a jump from 168 to 420. He was like, realized this was a really sort of strict work standard to meet. And he did some research, and he realized the employer had used the wrong stats of the number of matriculants who were going to matriculate at the end of that year, and so were eligible to come to the Boksburg campus. They had used the wrong data, and so that the 420 was a really inflated figure. When this matter got to the Labour Appeal Courts, they said that to give someone 27 days to meet a standard, a work standard, wasn't enough, even though he was appointed as a senior employee. He was general manager of the whole Boksburg campus. He still needed enough resources to meet those standards. So this case held that the dismissal is unfair if the period to achieve the target is too short.
I think this is probably also an example, Alan, of what we were talking about earlier, perhaps of an unreasonable performance target that was set in this instance, given that the wrong the facts were in fact used in this case.
Yeah, and this case links to the next principle, Bruce, about is this the employee's seniority or
well, can we ask our audience? Let's ask
sure
everyone that's tuned in. Let's ask you a question here. Can the employee's seniority affect how much evaluation, instruction, training, guidance, or counseling is required? What do you think? Is the employee's seniority a factor that would impact on this? Couple more seconds. And as you see there, 81% of you say yes, yes, it can.
Yeah, I think that's in that Damlin case we've just looked at. I think the learning there is that even though that he was appointed at a senior level, and the case said it doesn't need the same degree of training, but he does need to be provided with the resources to succeed. So it might not be so much training as resources.
Yeah, but certainly the level at which the person is in the organization would be a factor that could certainly have an influence.
Clearly, yeah.
Alan, can a single issue of poor work performance ever justify a dismissal? And in fact, let's ask the audience, what do you think? Can a single occasion of poor performance ever justify a dismissal? What do you think? I suspect we might have a more even split in answer on this question. Think about some examples that you might have dealt with at the workplace in answering this question. All right, a couple more seconds. It's a pretty even split. 56% of you say no.
I think, Bruce, it's going to be one of those situations each time whether this starts to look like misconduct or is it poor performance. And I think that's why the response was so divided there, that very often it's that single instance. If the question is, can a single instance of poor performance justify dismissal, it's going to depend on the facts. This case of Somio and Ross Poultry Breeders, it involved a senior manager who had been employed for 6 years and knew the chicken business very well. On one occasion, he failed to vaccinate newly arrived chickens timelessly. He forgot to order the feed, and he wasn't present when these chicks were delivered. And this really, it had the potential to cause huge loss. And in this case, it was regarded that the single failure to meet the performance standards was enough to justify dismissal. You can see how the employer could have treated this as an act of misconduct. I think this is one of those crossover cases, that it's almost like it looks like someone who just negligently doesn't care. But I think that because this case was framed as an incapacity case, a failure to perform, here you get confirmation from the Labour Appeal Court that a single failure to perform at the right standard can justify dismissal. Warning is not even required. But remember, this was a senior employee of 6 years standing.
Yeah, I think all those factors were taken into account. And I think those, whilst that Labour Appeal Court case said, yes, a single act can justify dismissal, I think those cases are going to be exceptional cases.
Yeah,
and the employer would have to lead very clear evidence about the potential consequences of a failure to perform at the required level.
And also the employer would have, obviously, in the 6 years of employment, have a clear evidence that the employee knew the standards and had performed them year after year. Yeah.
Let's move on. The next point to look at is whether dismissal is the appropriate sanction for not meeting the required standards. And the Code of Good Practice, item 8 or paragraph 8.3 says that the employer should look at other ways short of dismissal to remedy a particular matter. So what options could the employer think about? Well, maybe you would need to think about, if possible, to reallocate certain functions that are causing this employee problems. They could be done by a different person, and maybe functions could be reallocated between employees if possible. I'm not saying these always would have to be applied. It depends on the facts of each case. Is there particular help on the job that the employer could give to help the employee dealing with these particular problems? I mean, there was a case we dealt with years ago where the sales team, sales patterns had moved, and there were new issues in the marketplace, and this older person who was battling to now achieve sales under these different market, under a different sort of market, that they actually needed help to how to adapt to these new circumstances. Obviously, also you'd look at suitable alternative posts, either at the same level or at a lower level, that the person could perhaps do. And the question that we need to think about is, can you demote on a unilateral basis in these instances? And let's see what your views are on that issue. Can you demote unilaterally if an employee is performing poorly? What's your view? Those of you who are enjoying these polls, this is our last one during the webinar, so I hope you found them useful to keep you awake. Looking at the results, 73% of you say no, and that's absolutely right. That would be a unilateral change to the employee's terms and conditions of employment. You need the employee's consent in some shape or form, either because it was in the original contract of employment, perhaps, or you need their consent at the time that you can now demote this person to a lower grade. If the employee declines to accept it, well, then that's one of the pieces of evidence that you would use if the employee was subsequently terminated and you had to show that you'd looked at alternatives. These had been offered to the employee, they turned them down, and that might be a basis for saying why a termination was fair under those circumstances. Just a further question to think about is people often think, well, aren't you just transferring a problem? That this person hasn't been able to carry out their functions at the required level in this job. You've now transferred this employee into a different job. Aren't you just transferring a problem? Well, you've got to look at that and make sure that the alternative job that you're offering this employee, that he or she has the skills and ability to perform at that level and won't encounter the same problems that they encountered in their previous post. And you'd have to apply your mind to that to make sure that you're not just transferring a problem. Let's move on and look at whether, because this whole process of counseling, evaluation, and so on is part of the procedural fairness buildup. But is there then still a need, if all of that hasn't worked and you haven't found an alternative and the employee is still not performing at the required level, is there a need to hold an incapacity hearing at that point in time? Alan, your comments on this?
Yeah, I can really understand an employer who has invested in training and counseling and even warning to still face that when the employee shows no sign of improving, demonstrating an absolute incapacity to perform. You can understand them saying, look, I can hear the employer saying so easily, look, we've done all we can and it's really over. That's not the thing to do, although however tempting it is. The Code of Good Practice requires some kind of hearing. It says the employee must be invited to make representations and can even have a trade union rep to help with those representations. And I suppose you've got to think of what evidence the employer would need to bring. I don't think that evidence is ever going to be contested, that in fact the employer told the employee what was required, what the standards were, that there was training. All those things are likely to be common cause, that the employer's done everything required and waited enough time for the employee to show signs of improvements. But there's got to be some kind of hearing. And if the evidence might be contested, I agree. And in that case, the employer will have to lead some evidence at that hearing for the record, in case this gets to the CCMA, that in fact the performance standard was reasonable, it was achievable, that the employee did not meet them, some kind of evidence, a manager giving evidence that this happened. And you have to give evidence that there was sufficient assistance, and so on. And also that issue you raised, Bruce, about are there any alternatives to dismissal? So that's what the hearing would cover.
Because there could be disputes of fact over any of those issues, which I mean, if they aren't in dispute, well, then that's fine. You would just it would be common cause. But if there are disputes of fact on any of those issues, you would have to be prepared to lead evidence to prove your case on those issues.
Correct. Yeah.
Yeah. All right, let's look at how does probation affect this, and is there a difference with managing performance during probation to after probation? This is item 8.1 of the Code of Good Practice, and it's one of the most poorly, I think, drafted sections of the Code of Good Practice. But it says any person making a decision about the fairness of a dismissal. So you as chairperson of an inquiry, an arbitrator at the CCMA, a judge in the Labour Court, any person making that call about the fairness of a dismissal of an employee for poor performance during or on expiry of the probationary period ought to have accept reasons for dismissal that may be less compelling than would be the case in dismissals affected after the probationary period. So it's a fairly long-winded, clumsily worded section, I think, but it basically means it would be easier to dismiss during probation than would be the case after probation. You wouldn't have the same obligation to go to the same extent of evaluation, counseling, training, etc., during probation as would be the case after the probationary period. And there's one Labour Appeal Court judgment on this which I'd like to draw to your attention. It's this Ubuntu Education Fund case versus Paulson. It's a Labour Appeal Court case where the Labour Appeals Court said, whilst probationary employees are still entitled to fairness, arbitrators should hesitate to interfere with employers' calls on whether whether the employees have attained the required performance standards. So if you are dealing with a case of a probationary employee and you've made a call on this, I think this judgment would be helpful to you in substantiating your case.
It was just to say that runs counter to the idea that in misconduct cases, the CCMA does not have to defer to the employer's judgment. This was a dismissible offence.
Correct.
The commissioner's got to hear the evidence, make up their own minds. Whereas in this case, it's saying that there should be some deference to the employer's decision.
Yeah.
Alan,
any sort of last closing comments on having the right kind of approach and attitude to managing these issues?
I suppose the word managing is what's really the comment I'd like to make. So often performance issues are seen as quite a stern managerial function. It's quite interesting. My wife, Romy, does a fair amount of coaching for an organization in Stellenbosch where young people are brought into the wine industry. And just last week, she went to visit some of the students who were on their internship in different wine estates. And two of them were just radiating with joy about their internship experience because the manager had made this induction and the training such fun, they said, and it was done with a real encouragement and with it wasn't seen as if they were managing performance. They were just being trained about the job, and they were so positive. And I suppose that I was quite moved hearing that story, realizing there are two ways of seeing it, as about empowering people as opposed to being strictly managerial and seeing people step outside the lines. And that attitude, I think, can make a big difference in performance management. If you're a manager, what's your job? And I think it really is about empowering until the point is reached where the employee has demonstrated they're just not capable. Then you've got to approach it slightly differently. But certainly,
I think it's a question of coming alongside the employee and saying, what's the problem here? How can we help you? And not using the process as almost like a tick the box kind of approach that you're going through the motions so that you can substantiate that a termination was fair at the end of it. Coming alongside the employee, helping them overcome problems that they might be experiencing and seeing if they can achieve the required performance standards.
Yeah, that's exactly it.
All right. That was the content we wanted to share with you. We've taken about 50 minutes in doing so, so we kind of online. Just to the last slide I want to show you, those of you who are not Worklaw subscribers, just a bit of a sales pitch. If you are not a subscriber, just some of Worklaw's key services. We have all the cases online. We update you weekly and monthly on what's happening on the cases and news. We give advice via our helpline. We've got a law library online dealing with all aspects of labor law, unfair dismissal, unfair labor practices, unfair discrimination, etc. All the laws are up there. We've got model procedures, checklists, and so on. And we run these webinars for our subscribers on a couple of times a year. So those of you who are not Worklaw subscribers, if you have an interest, email me and we can give you a free 3-day use of our services to see whether you like what you see. So just send me an email and we'll log you on. All right, let's deal with any questions that have arisen. Alan, you can answer the hard ones. Let's see what we've been asked. And the first question is, an employee unquestionably has the capacity to perform, but performs poorly. Is this misconduct? Alan?
Well, one of the things you raised right at the beginning, the test of misconduct is where the person has the capacity, so that's part of that, but intentionally or negligently fails the required performance standards. So I think the person might have performed poorly through something that's not part of negligence or intention. They might be having a really terrible time at home. The child could be sick or that kind of thing. So I think you've got to really ask if there's intention or negligence in this performance. And yeah, so I think that's how I would decide it. Bruce, I don't know what you'd think.
Yeah, I mean, I think that you've got to look at the facts of each case, but if there's no obvious apparent reason, the person knows how it has performed at that level in the past, and it sounds like in the absence of any other explanation, the person might have a drinking problem, might be something like that, that's then incapacity, ill health perhaps. But in the absence of those explanations, I think it sounds to me like it's a misconduct case.
Yeah.
All right, there's a question from Jan. Is there something specific to keep in mind after a process to enhance poor performance after high levels were achieved in the past and then dropping without any reason or more tasks added? Jan, I think, my answer would be almost the same as the first question, you've got to investigate, well, you've done this before, you performed at a high level for 5 years, but over the last 3 months, your performance has dropped substantially. You used to achieve X number of sales, you're now only achieving Y, or depending on whatever the job is. Again, you've got to investigate. Certainly the person has shown in the past that they're able to meet the required performance standard, which then also possibly shows that the standard is reasonable, that the employee knows it. But what is the problem? And it doesn't require you to then come alongside the employee and investigate what the cause of the problem may be. Has the market changed? Are there market forces out there that have changed, which the employee can't adapt to? What is the problem? And then to deal with it on that basis. I think as the facts unfold, you would then deal with them based on those facts as they unfold. Is it misconduct? Is it just they don't care? And they're not just, they have all the skills to perform, but they're just not, they are lazy perhaps, or depending on what the issues are, and you would then deal with it as such based on whatever facts emerge. Alan, any comments?
That's fine, yeah.
Sure, this is a long one. A commercial contract requires certain standards of performance from the supplier, e.g., a product has to be sent there on time and without defect. The supplier failed to meet these requirements on numerous occasions. The customer then held the supplier accountable for breach of contract and demanded the removal of the CEO. The contract holds the CEO ultimately accountable for the delivery under the contract. How should the supplier deal with such a demand?
Bruce, I think that if there's been a breach of a contract, there's what the client can ask for is compensation if it can prove the loss. I don't think you can demand that the CEO be fired. I mean, that's not. I don't think the law would ever recognize that as a natural and logical consequence of a breach of contract. It's an emotional response. You know, the CEO is incompetent, and because they're ultimately responsible, they must go. That's not a legal demand as far as I can see.
You know, this comes up in a whole range of circumstances where a third party demands a dismissal of an employee, be it, in this case, the example given to us here is the CEO, the most senior person in the organization, but it could be a salesperson that a third party who has a contract with you just takes a dislike to the person they're dealing with, or it's a security guard in your employ, and one of your customers has had an altercation with the guard and demands that he or she be dismissed. I mean, there are cases on this. There are a number of cases on this, and it does, as I recall, and Ellen, you might recall these cases better than me, but it does require the employer to engage with the outside party to attempt to address their concerns and to avoid the employee being dismissed as far as possible.
Yeah. I think the case,
but I think that there are circumstances ultimately where if that third party is saying, look, I'm going to cancel my contract with you, and if your business depends on that contract, and your future viability of the organization depends on that contract, I think there's an argument of incapacity here that can be raised in these circumstances. But the cases, as I recall, clearly obligate the employer to engage with the third party to attempt to address the issues to avoid the employee being dismissed at the end.
I think my recollection, Bruce, is that the cases usually involve employees demanding the removal of a manager. This is an outsider, and this is a commercial contract.
No, I'm talking about outsiders. Yeah. Anyway, I hope we've answered that question as best we can. In training, I think this is from Ingrid. In training, I use the following test to determine whether the behavior of the employee is indicative of misconduct or incapacity. Why did the employee behave in the way they did? 2, is the behavior due to circumstances beyond the control of the employee? If the answer is yes, then it is incapacity. If the answer is no, then it's misconduct. And Ingrid goes on to give us an example. So, I mean, I think that's a very useful test, Ingrid. And I think you are spot on there in the test that you've applied there. Ellen, any comments on that?
Yeah, the first question, why did the employee behave in the way they did? It's that you're relying on the employee to be fairly honest there. You know, it's quite a subjective, but I think the second question balances it. Is the behavior of the employee due to circumstances beyond the control of the employee? Well, it might just be ability, I suppose. This person, these are useful questions. Just thinking about you think an employee just does not have the ability to do the job. Do these questions help exactly there?
Well,
I,
it would be in answer to question 1.
why did the employee behave in the way they did? Because they're just not able to do it. Yeah.
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 All right, let's move on. Jan again. During the process of assessing poor performance, the employee mentions that the promotion recently is raising the bar too high and wants to go back to the previous position. Is the employer obliged to move the employee back to the previous level, which vacancy has already been filled with a more junior person? I don't think so. I mean, again, as I said, when an employee is promoted into a more senior post, I think there's a bigger obligation on the employer to engage with that employee to ensure they are able to perform at the required level. So there's I think a higher level of consultation, evaluation, counseling, training, etc., which is placed on the employer in those circumstances. But once the person accepts that job and is then, and their previous job has been filled, that person has to perform in that job. They have no right, depending on what's been agreed between the parties, but they would normally have no right to just to return to that previous post. You might find that this person is then incapable of performing at the required level, incapacity, poor work performance, and you've then got to look at other options, a different job at the same level, a different job elsewhere in the organization, and if those options are there, then you would then place that employee in that alternative job if they consent to the alternative job. But I don't think there's any automatic obligation, Jan, to place the person back into their previous job. Alan, your comments?
Yeah, I would agree with that.
Okay. Next question. Incompatibility. What test should be applied, and do you charge both or an aggressor if identified as such? Alan, do you want to answer that?
Well, I think the test is whether there's an employee who's unable to work productively, perform productively with their colleagues, and is causing hostility. So that test isn't well formulated, but it's that kind of test. Is the person's performance really creating conflict in the workplace? And despite being approached and counseled and given a chance to improve, the person continues to really cause problems with the other employees. I think then that's the test would be satisfied. But it says, and do you charge both?
An aggressor or the aggressor if identified as such. I mean, I think, I mean, going back to your comment, Alan, when we dealt with this during the webinar, you know, incompatibility does often manifest itself as a form of misconduct. Someone's abrasive, they're rude, they aggressive, they do something at the workforce. So it can actually be dealt with as a misconduct case in many instances because of the facts of a particular case. But if there's no real misconduct and people are just like there are square pegs in a round hole and people are just not getting on, the team is not functioning, there's no misconduct, well, then you've just got to investigate what is the cause of the incompatibility, and it does require you, I think, to investigate the facts of the case and to come to some conclusions about who's causing this, and maybe then it's maybe there's more than one person involved who's incapable of performing and being compatible with the team, but the facts of the case are going to determine A, whether it's misconduct or not, and B, if it's incapacity, which party is responsible for that, for the incompatibility in the team. What do you think, Al?
That's right. There is a case which says the workplace inevitably is going to have mavericks. And I like that word because we all know that from our working experience. There's going to be somebody who thinks differently, responds differently to us. And I think the workplace is meant to accommodate that and to be tolerant. But when that starts to be provocative and starts to destroy relationships, I think a point's been reached when it's incompatibility and there's it becomes a performance issue. But it might, of course, depending on the circumstances, as you say, bubble over to a misconduct situation with a person that goes way beyond just normal interaction to something quite rude, quite hostile, you know?
I mean, obviously, and I know it's an easy way to answer these questions, but I think the facts of the case are important because, as you say, the person may be a bit of a maverick, but the cause of the incompatibility is other people's failure to accept that slightly unusual behavior. So maybe it's the other conservative people who are not accepting the maverick who are the cause of the incompatibility. But
Sure.
The facts of the case are going to have to determine that one way or the other.
Yeah.
All right. Are there any more questions?
Yes, there is.
My question is on the Somya versus Ross Poultry. Can a one-time poor work performance warrant dismissal? I feel like the question was open for interpretation, hence most people said no. Some interpreted it as a question of poor performance as a result of lack of training, ill health, whereas answer covered misconduct. Yeah, a good point. I mean, I think that always when we ask these simple questions, the facts of the case are hidden behind those fairly simple yes/no questions. I think the importance of that case, and Ellen, you can comment as well, was that it did say that, I mean, it obviously depends on the facts of each case, but there are circumstances in which a one-time poor work performance may warrant dismissal based on the facts of the case and the consequences of the failure to perform at that level. I mean, for example, if a CEO makes one call about changing markets, new models in a car manufacturer, and reads the market wrongly. If the coach of the Springboks believe it or not, in the World Cup final chooses a 7-1 split on the bench, and that's a completely wrong call, and they would have won the World Cup had they chosen a 5-3 split. I'm choosing an example just to get people's attention, but maybe there are circumstances where a single judgment call by a senior person, for example, certainly does warrant their termination because of the consequences, the highly substantial consequences of the calls that they make at that level. Don't know if you all agree with me about the 7-1 split. Will a recording be shared? Yes, it will. We will have a recording shared on the Worklaw site after the webinar. Sean asks, when dealing with sales consultants, is an employer obligated to always follow the poor work performance process for an employee that is not meeting sales targets? Ellen, do you want to answer that?
I think there needs to be an interview with the sales consultant to understand why the sales aren't coming in. I mean, you know, there could be some real objective reasons why the market might have changed, all kinds of things. And so I think there's needs to embrace the poor work performance process to some extent before you start to think this person is intentionally or negligent about their work, which turns it into misconduct. But if there's a person who is going out meeting potential clients, but the sales aren't being made, there could be other factors, market factors. So I think my advice would always be to start with the poor work performance process.
Absolutely, yeah, I think so. I mean, Sean, I'm not sure if we're understanding your question fully, because I mean, I know that you're an experienced guy, but I see no reason why you wouldn't do so. That whole process of evaluating, counseling, looking into the facts is going to determine where the problem lies. So I think, yes, I think you would follow the poor performance process. that we've outlined. You would check whether the employee knows about the performance standards required. Are they reasonable? Have market forces changed or not? And why? Well, why isn't this person able to perform at the level that they perhaps previously did, and that all your other sales consultants are achieving at the same time? So yes, I would say that you would. Those are all the questions. We've taken an hour and 10 minutes, which was about what we'd planned for this webinar. I hope that you found it helpful. We've tried to be as practical as possible in dealing with daily sort of problems that you can experience in this area. We try to give you an outline of the kind of evidence that you'd need to lead if you ever had to defend the fairness of a dismissal based on these circumstances. If there are any other questions that you've got, please feel free to use the Worklaw helpline, and we'll do our best to answer your questions. So thanks for being online. I see most of you are still there, and we appreciate your attendance. Thanks, Alan from Cape Town, and enjoy the rest of your day. Cheers all. Bye.
Thank you. Bye.